Thanks for coming here on this morning. Today I'm going to talk about something very general regarding how you could advise your clients about wealth management and asset protection. These are some of the points that I'll cover today. First, what is wealth planning and asset protection? We hear these words a lot, and I'm sure your clients would have heard them as well. There are certain misconceptions associated with that, and it will be useful as well for us to understand what these terms mean. Reasons for planning, how can trust or foundation help? And these are not just the only tools when it comes to wealth planning and asset protection planning. And there are also other considerations as well. And when do you start planning? Now, what are the common misconceptions that we normally see? To a client, they think that wealth planning is just buying an offshore company or a company in an island they have never been to. I have clients that are telling me, if I buy a BVI company, I don't ever have to pay tax again. Is that so? What is the BVI? I ask them. They don't know what it means. Hiding assets, layering companies upon companies to them. To some people, this is considered asset planning. It is not asset protection planning. Okay? These are common misconceptions that some people have. But of course, there are also very sophisticated clients as well. And there are also legitimate reasons for wealth planning, and it's useful to identify what these reasons are. Well, firstly, we have succession planning. Now, that's succession not just in terms of private wealth. Of course, private wealth is one area for planning, but also business succession, especially in family-established businesses. We're also talking about efficient asset ownership structures, efficient in terms of tax, as well as risk management. And then we also think about wealth planning in terms of bypassing probate formalities. There are two things that are certain in life, as I was talking to someone about just now, death and taxes. And when a person passes away, usually in common law jurisdictions, you would have probate formalities to go through. And what does that entail? That entails applying for grant of representation for the executor and administrator to have the authority to administer the assets of the deceased person. Well, if there is a will, the grant of probate application is essentially the process of proving the will in court. In other words, for the executor to prove his title. Now, even though executor may have derived his title from the will, they still have to go through this probate process. It takes some time. Sometimes the probate process could also be challenged by disgruntled family members or an unhappy situation at home where people challenge the suitability of the person who becomes an executor. Anyway, even in straightforward cases, assets may not be transferred until the grant of probate has been extracted, which also means that essentially the assets are frozen. You can't transfer it to the beneficiaries until the grant has been obtained and for the executor to effect the transmission or the transfer. So there are some benefits to doing planning which could help bypass these requirements for probate formalities. Then there are also forced heirship concerns, or rather concerns whereby a testator may have restricted testamentary freedom of disposing his estate by will. These are quite common in the case of clients who may be subject to Sharia inheritance laws, or clients who are subject to certain jurisdictions' forced heirship rules, for example, in Europe. And another legitimate reason for wealth planning is taking care of disabled or spendthrift dependents. This is actually a real issue. You could have a beneficiary who is disabled but in need of money, and you need a person, a trustee or a manager of funds, who may not be the same person as the caregiver to that disabled beneficiary. So there is some planning required there. And of course, spendthrift dependents, to protect them, and to protect them from their creditors. And privacy concerns. Privacy concerns, well, for example, if you were to do up a will, and a will gets probated in court, by and large, the terms of the will is public. I mean, it's not public in the sense that anyone can view it, but because it is probated, it is in court, it is public. Whereas the terms of a trust, for example, is not required to be registered with any registry. These are usually kept outside the scrutiny of prying eyes. And increasingly, you see high net worth individuals expressing a desire for charity and philanthropic aspirations, and as well as what is commonly known as asset protection. If we're talking about asset protection, what exactly is it that we are talking about? Who are we protecting the asset from? An example includes a judgment creditor. This is a party to which a debt is owed who has proved his debt in a court proceeding. But of course, as with any asset protection planning, there are also bankruptcy laws to consider. For example, the disposal of asset within a certain period may be clawed back for bankruptcy proceedings. So planning way in advance is useful. Who else? A divorcing spouse, or a dissatisfied heir, or because of expropriation or political instability. So these are some of the possible protection that's required. Now, why is there a need to plan? This is actually a sign of our times. To start with, we are now living longer. We have more funding needs, and there is more amount available for inheritance. And with that, there's also the increased quality of life, okay, as well as increasing healthcare costs. The fourth point I want to make is that cross-border mobility. Now, this takes place in many arenas, including immigration status, when a person moves from one country to another, as well as asset and wealth accumulation in various territories. You could have your business established in one country, and there are people who have assets or investments in other countries, as well as intercultural marriages. Intercultural marriages includes marriages between different nationalities, as well as conversion of religion. So these are all issues. This also means that there is greater exposure to cross-border legal and regulatory differences. So these are things that needs to be paid attention to as well. And then there is rising divorce rates. It has an impact on family wealth available for inheritance where there's a divorce by the wealth creator. And then in modern times, of course, there are quasi-matrimonial and cohabitee rights, which are not regulated by matrimonial laws. And then you have unexpected events, such as political instability, terrorist activities, and natural disasters. These are disruptive events which increases the need for comprehensive solutions for asset ownership protection. And then we have needs driven by economic and financial uncertainties. So there is a need to address both preservation of wealth as well as growth and performance. So we want to preserve, but we also want to make sure that there is growth. So what are the tools for asset protection and wealth planning? There are actually many. Let's take a look at foundations and trusts first, just broadly speaking. There are some similarities between the two. As I mentioned, I'm not going to go into too much of the technical details of each of these possible alternatives, but rather give a broad overview of what the similarities and differences are. Fundamentally, a trust, you have a settlor, although a settlor is not necessarily required for the creation of a trust. In the case of a foundation, usually there is a founder. And in the case of a trust, there is a trustee, and the equivalent in the context of a foundation, the council and officers. What are the terms of the trust? You have the trust deed. In the context of a foundation, you have a charter. In the trust, it's possible for settlors to have reserved powers of investments, as you can see in certain jurisdictions. Just because a settlor reserves powers of investments to himself does not necessarily render the trust as void. Similarly, in the context of a foundation, you have a situation where founders can reserve powers of management as well. And this reservation of powers is a desire expressed in succession planning. But what are the differences? Well, fundamentally, a trust is very different from a foundation in that it is not a separate legal person. In fact, a trust is a relationship. It is a relationship between the person who holds title to the asset and the person who will be benefiting from the asset itself. It is a relationship that requires the three certainties. The certainty of intention, that means the intention to create a trust. There is the certainty of a beneficiary, the objects of a trust, as well as the certainty of subject matter, which is property. But trust has developed quite a fair bit in certain jurisdictions. In certain jurisdictions, it is possible even to have what they call a purpose trust without a beneficiary. And of course, the trust law has been one of the most innovative mechanisms to evolve from English law itself. The assets and title, the assets and the title of the property are registered in the trustee's name or the trustee's nominee name. So it is the trustee who has the right to sue or be sued rather than the trust itself, because the trust is just a relationship. Whereas a foundation, because it is typically a creature of statute, it is a separate legal person. It is able to be sued or sue. There is a requirement to register a foundation as well. There's no such requirement to register a trust. Okay, for instance, I understand under the Labuan Foundation Act, there's particular requirements for the foundation's name, registered office, keeping of council minutes at the registered office. Now, the liability of the trustees are governed by the trust deed as well as trust law, whereas the liability of council member and officers are generally governed by legislation. And another feature of trust is that there are certain limits to duration. This is what is known as the rule against perpetuities. In other words, the rule against having a trust that lasts forever and ever. Again, there is an exception to this, and that is the charitable purpose trust. A trust that is created for charitable purposes fall outside the rule against perpetuities. Now, even this distinction may not be so relevant these days, where in certain jurisdictions you can also have perpetual trusts. But that is one of the traditional distinguishing factors. And then you have the issue of revocability. Depending on the terms of the trust may be revoked. Okay, and whereas a foundation, liquidation and winding up typically specified by legislation. There are other things that we need to consider as well. Who has the right to enforce obligations in the context of trusts and foundations? As I mentioned just now, trust is fundamentally a relationship. So the person who can enforce usually is the beneficiary. Now, in the case of a trust, there's usually a split between legal and beneficial ownership. To put it simply, the legal ownership rests with the trustee, while the beneficial ownership rests in the beneficiary. This, of course, is a very broad and general statement because there are also overriding common law considerations. Because in certain instances, this is known as the rule in Saunders and Vautier, beneficiaries have the power to unwind or terminate the trust as long as they are sui juris or are capable or not under any disability and are consenting. In the context of foundation, there are beneficiaries to a foundation too, and their rights are also specified under the legislation. But there's something very interesting about, for example, the Labuan Foundation Act. Okay, it says that a property endowed to a Labuan Foundation shall not become the property of a beneficiary unless the property is distributed. So unlike a trust, there is no such thing as a split concept of legal ownership versus beneficial ownership. It is quite clear that a property endowed to a Labuan Foundation only becomes the property of a beneficiary when the property is distributed, and not otherwise. As for overriding powers or overriding considerations, in the context of trust, as I mentioned just now, in certain situations, the beneficiaries could terminate a trust. In the context of the foundation, the regulating authority also has certain overriding powers to strike off or have the power to prosecute for offenses with the consent of the public prosecutor. And as for carrying out commercial operations, trusts have also been used in the context of unit trusts. These are quite common, and people are very familiar with them. The suitability of carrying out commercial operations, of course, depends on the details of what type of operations need to be carried out, as well as the use of the structure, whether it is for investment, vehicle holding, or to make sure that certain active businesses could be held under the structure. Well, The key takeaway I have is that it's not one or the other, or that one is better than the other. And certainly both have been used in planning before in the same client's case. And the suitability of either of these tools serves different purposes. And these are just one of the many tools, some of the many tools that you can use. Okay. A very important one, and everybody is familiar with this, is wills. You still need to make a will regardless, as long as the client still holds assets under their own name. Okay. The will also allows you to appoint an executor, a person who will be responsible for administering the estate. The other tools, of course, tools that I've seen in, for example, in Singapore, a lasting power of attorney, an instrument which allows a client to confer authority on another person to handle his property and affairs when he is no longer able to do so, for instance, due to mental incapacity. This is, of course, very important because of increased longevity. And also, having an instrument like that, if it is available in the jurisdiction where your client is helpful in the sense that there are situations where you have already planned for the worst, that is when the client has passed away. But what if the client hasn't passed away, but is not capable of managing their own affairs? And who will be the authorized person to do that? Traditionally, of course, there are also other ways of dealing with this issue. That is to apply to the court to appoint a deputy or a committee of persons who can then take over the patient's matters. But sometimes this could be quite time-consuming. And also, infant children, who will be responsible for looking after them or taking care of them. This is less of a wealth planning issue, but it is something that the client should consider as well when talking about succession planning. A living will, an advance medical directive, stipulating what happens at a very critical point in time, when they are no longer able to make the decision of whether to be kept on life support or not. Another way of planning, of course, is the joint ownership of assets. This, of course, depends on what type of assets these are and whether in the jurisdiction where your client is, whether there's a possibility of property passing by way of survivorship to the joint owner automatically. Of course, there are benefits to having such a tool. You bypass probate formalities. You don't have to have the problem of having a period where the assets are frozen and nobody can deal with the asset. And of course, it allows dependent family members to have quick access to the asset. And of course, insurance, to ensure that there will be payouts to dependents. Use of nominee companies. This, I would look at it with care as well, and to see whether this is actually something that is useful for that client's particular scenario. A nominee company is useful in certain situations simply because a company doesn't die. A company lives on forever and ever. But then who owns so you could have a company owning the asset, but then the question is who owns the shares of the company? If you have individuals owning the shares of the company, you still have an issue of dealing with individuals who might pass away. So nominee companies could be useful in certain structures, but still has to be viewed with certain considerations, taking into account the cost of maintaining these companies. Then there are companies limited by guarantee, a very, unlike a company limited by shares, you don't have shareholders. It's, traditionally viewed as a kind of company that can be orphaned, but you have members of the company. The choice of who becomes the members of the company then becomes another consideration. Prenuptial and postnuptial agreements, or even agreements in cohabitation scenarios or quasi-matrimonial scenarios. And then broadly, for certain high net worth individuals, they desire to have something that could last for a longer time and hopefully bind their family. A family governance framework where you have family council, a family office, a constitution or charter. And these could serve different goals, whether it is the long-term dynastic wealth preservation goals, or active management of funds for growth purposes, or have a philanthropic arm in the entire framework, as part of the framework. There are some points that we have to think about when we talk about wealth planning or asset protection planning. The main thing is to take into account the objectives of the settlor and founder. What is their requirement? I think we spend a lot of time understanding what our clients' requirements are, as well as the differing needs of beneficiaries. Different beneficiaries could have different needs, and yet at the same time, we need to take into account how to plan that in the greater context of things. There's also the need, especially if you have clients with multi-jurisdictional footprints, to understand the differences between the various legal systems, whether it's common law, civil law, as in European law, or Sharia law. And the nature of your client's assets. What are these? Are these business assets? Are they immovable properties? Are they shares? And if they are shares, are they private shares or listed company shares? Cash? Jewelry? I once had a client who made a will. He had many jewelry, and he took a photograph of every one of them and labeled them because he wanted to give each piece of jewelry to different beneficiaries. And valuable artworks, okay? The way these are being distributed, or the way these things are being held, involves different risks and management strategy. And then, especially with clients with multi-jurisdictional footprint, you have asset ownership in different countries and territories. You will also have different requirements and considerations when it comes to transferring those assets to their intended beneficiaries. And of course, as with setting up any structure, you have to think about the tax implications. Traditionally, a trust will be treated very differently from, say, a company for taxation purposes. And we're talking about tax implications not just on the setup, ongoing as well, and future restructuring or possible winding up of the structure. Because as time goes by, as we know, people's needs change. And again, if you have a situation where multiple jurisdictions are involved, the different tax considerations in these jurisdictions will have to be paid attention to as well. And what drives one to choose a particular jurisdiction? Well, the legal system is one of them, political stability and economic infrastructure, as well as the ease of doing business. So, when do we start to plan? Obviously, when the client has the capacity. When the client has the capacity to make the decision and is able to understand. Always plan in advance, not wait until there's a pressing need or a pending storm or pending disaster. By then, it will be a firefighting exercise rather than a planning exercise. Also, changes in family circumstances, whether it's before marriage or before the marriage of a child. It could be a complementary tool to a prenuptial agreement, or upon marriage, because a person may have made a will before marriage, and once a person marries, a will may no longer be effective. How about new addition to the family? Now, new addition to the family, if it's a biological child born to a couple who are married, that situation is usually very straightforward. Okay, how about adoption? Well, legal adoption is usually quite straightforward as well. How about foster children? How are foster children regarded in that particular jurisdiction? How about children who are born to cohabiting couples but not married? Okay, are children born outside of marriage recognized in the relevant jurisdiction? These are issues to consider as well. And then we have migration. Family members move, family members acquiring new immigration status or resident status in another country. Are there any tax implications or inheritance tax consequences to be aware of when a family and his descendants acquire a new status in a different territory? There are also other situations in which planning opportunities may come up. For example, upon retirement, when a person retires, the needs are very different. Their goals and objectives are very different. How about business succession in the case of a wealth creator for his family? And when a person receives gifts, legacies, or inheritance, these are also opportunities in which questions regarding planning may come up. And what do clients need? I'm very sure clients need a lot of things, and this list is obviously not exhaustive. They want tax efficiency. They want something that's easy to understand, that is legally enforceable, that is confidential. There's no time zone delay, no force majeure risk. It's economical, scalable. They want an advisor who can be easily contactable. And most importantly, I think this is something that, as advisors, we also need to pay attention to, is a cohesion in planning. Sometimes clients are reluctant to tell us what they're doing in other parts of the world or in other parts of their they could come to you for private wealth planning, but sometimes this is driven by other considerations as well. So it would be nice to have a situation where there's some cohesion in planning. A very straightforward example, of course, is in making a will. There are often times when we see wills being made to cover a worldwide assets. That means assets of the client all over the world. And yet, later on, another will surfaces to say, this will only covers assets in, say, Australia. So which will should prevail? This becomes an issue. This is not a problem of the lawyer. It probably isn't a problem of the client who didn't think about it. But you see, when some people make a will and they want to make a will that governs assets in a particular territory, they forgot to tell either their former lawyer who made their worldwide will, or to tell their current lawyer they had actually made a worldwide will. So this is a very classic example, but there are other aspects which could arise as well. And certainly, going forward, there is an increasing need for tax-compliant planning structures due to the exchange of information requirements, and this is a global trend. This is not something that the client can avoid, which is why taking advice is necessary. And paying attention to trends. Another trend that we would see, of course, is voluntary disclosure programs that are conducted by a particular authority in the client's home territory, for example. And that involves the unwinding of any structures which they may have set up in the past, thereby triggering certain implications in the jurisdiction where they are in. But this is unavoidable if voluntary disclosure gives certainty to the client in their home country vis-à-vis their regulatory authority. And with that, I've come to the end of my short presentation. If there's any questions, feel free to ask me.